Hello landlords and fellow professional property managers. I'm Tony Klein with HomeVault Property Management, and I'm here with another legislative update for the state of Colorado. So the state legislature has introduced a bill number 20-1009, and that bill is actually about suppressing eviction records. And here's why this bill is problematic for landlords and property managers. Typically, when we're screening a tenant, we have a few areas that we're allowed to screen. We can screen credit, make sure that they're creditworthy and that they're going to pay the rent. We can screen their criminal background. We can screen for their income and previous employment, and we can screen for previous housing. So this one is going to really focus on the previous housing portion of tenant screening. What this does, this bill that they're introducing, would actually suppress any eviction records. So let's say there's a tenant, they go, rent's due on the 1st, and at some point you decide throughout that month that they have not paid rent. So at this point you decide to file your 10-day notice, which gives them 10 days to pay or quit. And at that point, after that 10 days, if they've not complied, then you begin that eviction proceeding. What happens at that point is it'll go through the courts, and typically what happens is the judges want you to negotiate with the tenants. And here's where it becomes problematic. If we're unable to look at their previous housing to determine whether or not they've had eviction proceedings filed against them, what happens is that a problem tenant that may have had trouble in the past and may have not paid rent in the past and may still owe monies to a landlord, well, if those eviction records are suppressed, then we won't know if they're a good quality tenant and that they pay their bills, honor the terms of their lease, those sort of things. Now, it does say that in the event that a judgment for possession is entered into, which means it's gone all the way through the eviction process, we've got an eviction, the judge rules in the favor of the landlord, and the eviction actually is going to take place, then at that point it says that the suppression of the eviction records will be lifted. And it sounds good in theory, but what usually happens is during that negotiation, a landlord, a property manager, they just want that tenant out. And so there's an agreement that's made oftentimes that the tenant will move prior to the actual physical eviction in exchange for something. And so at this point, where I see the problem with this is that if we negotiate prior to getting the order for the full physical eviction, then the tenant's records will remain suppressed. And so you can have these con artist tenants that continue to go throughout the process and time after time continue to get away with not paying the rent, not honoring the terms of the lease. And it really creates a burden for the landlords, especially landlords that only have, say, 1 or 2 investment properties, and they count on the cash flow in order to pay that mortgage payment so that the tenant has a place to live. So this is House Bill 20-1009, and it's actually going to be heard on January 23rd. So if you can, contact your state legislature before then and see if we can do something about this. If not, just realize this is something that we're going to have to live with in the future. There are a couple of other bills that come along that I'm going to address, but they're all playing together, and it's really creating a burden for landlords who are providing housing for tenants so that they have a place to live. So again, Tony Klein, HomeVault Property Management, and I hope you've enjoyed this update.